All right, any other
Good afternoon.
set overs or good afternoon?
Good afternoon. I will be.
My audio.
Whoever is Donata, if you could stop unmuting yourself, I would appreciate it. Thank you. All right, go ahead. Sorry.
Good afternoon, Your Honor. I am going to be requesting a continuance on the Mobs v. DOS matter, but that is not agreed. So just wanted to let you know.
Okay, so Ms. Maines, you're asking for a set over, and Ms. Winkles, you are asking to be heard today. Is that correct?
That's correct, Your Honor.
All right, so Ms. Maines, I'll start with you with a reason for the request.
Thank you, Your Honor. And I represent the respondent, who is the responding party to this temporary orders motion. I found out yesterday that my client's declaration was not filed because it contained color in the exhibits. So it's just her response is not before the court today because of that reason. And all of our materials are ready. They've already been served on opposing counsel. So I would only request a continuance long enough for the court to be able to review that response. And I mean, we found out about it yesterday. I notified Ms. Winkles as soon as I found out. No notice was sent to us that it was never filed. So I apologize to the inconvenience for everyone. This is the first continuance on this hearing. And I will also tell the court that my client completed a hair follicle test and we just got the results.
Object, Your Honor, that's not properly before the court, and it's an attempt to get in something that would normally be barred by the time limit imposed by Cowlitz County Local Court Rule 88.
Well, my argument, Your Honor, was that if we could reset this for a date where it could be before the court, I think it would be probative and informative for all of the issues that we are going to be discussing. That this was one of the largest issues at the hearing was my client's sobriety. So I believe it would be important, and I would request that the day that we reset this for, give Ms. Winkles enough time to respond to that hair follicle test if she wishes to do so.
Okay, and then the reply, I do have a reply declaration in the file.
Is that so?
And it's dated March 16th, and it has several exhibits attached.
Okay, I think that is the petitioner's reply, Your Honor.
That is, hold on. I could have sworn I read things from both sides here, and I have notes. Let me make sure.
To make matters more confusing, I actually filed 2 declarations from my client. One was a supplemental declaration that was also subject to a motion to exceed page limits that I filed, but that is not responsive at large to the petitioner's allegations. So that is a supplemental declaration completely, that's only regarding domestic violence allegations from my client. So her responsive declaration to what the petitioner alleged is not in the file.
Okay, so I do see that. So I have the response to the petition. Then I have a proposed parenting plan. And then I have a declaration affidavit that's titled Supplemental Declaration, Domestic Violence Claims. I also have the financial declaration, and it looks like sealed financial source documents. And okay. All right. Ms. Winkles.
Yes, Your Honor. So first, just to clear up a few things. This is actually the second continuance. While we didn't go on the record last time, the court will note that there is an email from my office asking for continuance, and that was on the request of Ms. Maines. We already gave them the continuance to make sure that they could comply with local court rules. In addition to that, by giving them that, we really cut ourselves off at the knees because we had to get a response back very quickly. We then get 2 declarations that exceed Cowlitz County Local Court Rule 88's page limit. There's no good cause noted, except we didn't have enough room to state this, that if you read any of the declarations, they waffle on, essentially using up page limits. We're all supposed to get under 6 pages. It's difficult to do. You have to choose the best things sometimes, but you don't just get to do a motion to exceed the page limits when there's no good cause. I just didn't have room. I objected to that, and I put that objection into the record. I objected to the page limits. Supplemental declaration, one of those declarations exceeds the page limits. There you have double, essentially, the page limits. The fact that the supplemental declaration was filed, that should be the one that was used. We all have to follow the rules. It's very clear what's in there. The attempt to get the drug test in, well, Your Honor will notice it's not an extended opiate panel, which means it doesn't test for any of the things we've said. Kratom is not tested yet. Hopefully it will be. That is the main issue. The alcohol, that's fine. So it goes back 72 hours. Second, my client, the reason that I objected is not only am I going to be away, I will be on the docket next week, but I will be away for 2 weeks. The main issue is that dad hasn't seen his daughter in 3 months. He hasn't had any contact with her. Pushing this off is pushing off that bond. This child was born in 2021. The necessity to continue to have an in-person bond with a child that age it can't be underestimated. And so continuing this another week when we've already given a continuance is really detrimental to the child and to the father's bond. So I would ask that we go forward today, a little bit of latitude in arguing what's not there. At least a page of the other declaration that it appears Your Honor didn't have was restated in more detail in the supplemental. So I'd ask that we go forward today.
And I just want to confirm you did receive their reply declaration. Okay, so I'm the only one who hasn't seen it.
And if Your Honor is inclined to put this over I ask for just 1 week, and I ask for nothing else to be filed after the deadline, because essentially what they're doing is they're prejudicing my client for not being able to see his child, but at the same time, they're getting this benefit of getting in something that would be barred by the normal time limit. So to ask that we argue with what's on the record, they can refile the responsive pleading, but the drug test would have been time barred anyway. So the fact that they didn't follow the court rules and they get this additional benefit doesn't seem correct.
May I respond to that, Your Honor?
Yes.
So opposing counsel said that this was the second continuance. I had every intention of getting this heard today, even though my client was served the night of the 21 service deadline. So I don't even know if opposing counsel complied with service on that, because it was the night of Tuesday. It wasn't before the end of business on the 21-day service deadline. So I don't even know if my client was properly served with timing. But we said, hey, if you give us a couple days to get our response to you, we'll keep the 21st date, because we had every intention of having this heard today. It's just that the court was not able to review a response that is very important for the court to review. There were numerous allegations on the part of my client. And one of the most important things is my client does a detailed narrative establishing that she was the primary caregiver for the child for the past since she was born. So that's very important and probative in the status quo and what the court will rule for the best interest of this child. And we will continue to offer supervised visitation for the father until this can be heard. So that's what we've offered previously, and that's what we will continue to offer. So he has an option to see the child if this can be continued. And again, I would argue that this wasn't even properly served to begin with. So, and this hearing has not been continued before. And then as to the drug test, I would just say that that the petitioner asked for that, we did it, and now they're saying they don't want it in the record before the hearing. So we're happy to give them time to respond. I don't know, it's a 10 panel. I don't know what other panels they want her to take, but we can discuss that outside of this continuance discussion. So thank you.
So I obviously I haven't seen the entire response of Miss Doss. I guess I have some concerns with I do see some concerns potentially with service. So I understand that, and I'm not going to hold that against anyone. And I don't know that it's interesting that I don't know the color issue from the clerk's office. That's kind of a new one. So I'm not sure if there was highlighted portions or something like that, that maybe those can't be scanned into Odyssey. So I'm not sure what the issue was, but I wasn't made aware of it. And I reviewed everything that has been filed, which is quite a few different documents just in this last month period of time. My biggest concern, to be very frank, I'm not necessarily opposed to a short set over. The biggest concern I have is I frankly don't see why supervised visits are necessary at this point in time. There's really nothing that's alleged that there's not appropriate care of the father, including the email sent from your client to Mr. Is it Mobs or Mobes?
And I believe it's Mr. Mobs.
Mobs, yes.
Mobs. Okay, thank you. So supervised visitation seems unnecessary at this point. And I'm saying that knowing that there's a declaration, responsive declaration from the respondent that I have not yet seen. But given her own words to the petitioner, I don't know that supervised visitation is necessary. I'm happy to set this over, but I think father should get a visitation this weekend, and I do not think it needs to be supervised.
Well, Your Honor, if I can make an offer of proof as to something contained in my client's responsive declaration that I think is a large part of the reason we are asking for supervised visitation, it has to do with violence texts that his adult daughter were in our exhibits that included him choking her out.
And I'm going to object to anything like that. Number one, the texts were, it says blocked at the bottom, but more importantly, it's hearsay. That person that apparently sent these texts is not before the court. We can't ask them the veracity of those texts, whether they were actually sent, whether the number is theirs, or anything of that nature. Because of that, it's hearsay. They're trying to prove the truth of the allegation, essentially, in those texts of what they're talking about. That is clearly not allowed in family court. It is still following the civil rules. It's not a protection order. Additionally, that declaration, this one was on domestic violence, the supplemental. So if we're talking about domestic violence, the issue, it would have been included in there. So that's my objection. Additionally, I still object to the page limit because there's no good cause. So I think they don't get to have their cake and eat it too. So I'd ask Your Honor, if Your Honor would be so inclined as to rule on the hearsay of text from a third party and also from the objection to the page.
Well, I will note, as I stated before, the responsive declaration that I did review is entitled domestic violence. And there's nothing in that indicates that there's some concern for the safety of the child. And frankly, just withholding the child and, is not looked at very kindly by the court.
Well, and Your Honor,
And
our response.
So it's my turn to talk, Ms. Maines. I'll set this over 1 week to the 28th. The father should have at least 4 hours of visitation this weekend to be agreed upon by the parties, and that does not need to be supervised. I'm gonna let the two of you work out where and when that is. And then we'll discuss this at the next hearing.
For a guardian ad litem
Thank you, Your Honor.
review temporary order. Mr. Baldwin is in trial today, so we're just simply asking to set over 1 week. The case does have a fairly complicated history with a lot of different motions and reports that have been filed over time. So I do think it's best addressed by Mr. Baldwin.
Ms. Peterson?
I don't agree. This was set over a month ago. I've waited patiently and I've turned in my mental health evaluation, and I'm, once that was turned in, I'm supposed to get at least weekend visitations with the children. And you're just pushing the matter out to where it's already been almost a year. This matter took place last April 17th is when the incident occurred. And I've only had recently the 2 4-hour visits a week. So if it's going to be set over for the goal to return back to the 50-50, I think I should at least be allowed to have my every other weekend as stated in the current temporary parenting plan.
So again, this case has a lot of concerning history and problems. She did file a evaluation, but I believe that wasn't filed until the 16th. What she provided her office isn't dated, and I don't see it in Odyssey. So what she wants to refer to isn't even in the court record at this point.
I filed it the day that I got it from the core mental health place.
I have a copy of it. It's index number 80 in Odyssey, and it looks like the evaluation was February 15th as the day it took place. And completed, looks like February 21st.
And then I had to wait the initial 2 weeks for their medical person to then release that medical information to me.
So again, my argument's simple. It's just Mr. Baldwin isn't available.
I understand that. The directions from her to her the last time we were here, excuse me, there was a parenting plan entered by Judge Hahn in June of 2022 with very clear outlines. Step 1 is this. She's been at step 1. Step 2 required the filing with input from the GAL and opposing party of a evaluation and any treatment recommendations that were made. I understand Ms. Peterson's position. I understand Ms. Baldwin's position. To me, it's a step up to step 2 at this point. She's been at step 1. So at this point, there's a parenting plan in place. She's abided by everything that she needs to get to step 2, which means alternating weekends from Friday at 7 until Sunday at 7 with a 3-hour midweek visit each week. That's not outlined in the parenting plan, so I don't know if that's to be agreed upon by the parties. But I'm and I'm happy if Mr. Peterson wants to note this back on and review it, we can do that, but she's complied with what was required of her for Judge Hahn's previous order, and that's what we set over to see if she could do. So I'm going to authorize the step 2.
So if the court's inclined to make that change, then I do want to argue it because she hasn't complied and I can point that out, but then you can go ahead and just put us into the regular stack and we can talk about it.
No, go ahead and go now.
Okay, so if you look at the parenting plan specifically, if you're looking at page 4, which is sort of the requirements above sort of the different steps, is she has to obtain the evaluation and begin the treatment that's indicated in that evaluation. So she has just obtained the evaluation, but we do not have track records of her obtaining treatment as recommended in that evaluation. So that evaluation specifically recommends ongoing treatment and therapy. We don't have any, essentially she's just filed the evaluation solely and wants to move to the next step. This specifically requires counseling as required for 4 consecutive weeks. So again, the idea is that she needs to show that she's done as not only obtained the evaluation, but also started treatment. Notably, this is also mother attempted in front of the children. And again, very dramatic thing that the children had to go through that happened essentially within the next couple of weeks is the 1-year anniversary of that. My client's concern is again, stability for these children and maintaining stability for both of them. The oldest is a senior in high school and not sort of upending the apple cart for him in the last couple months before he starts school, but also maintaining safety for the younger child because the brother acts as a protective factor for the younger child. So in this case, we do want to see that mother complies with the treatment that's recommended in the evaluation and that she's consistent in doing so. I think that's a big component. Once we've seen that, then it would be appropriate to start to increase time, but not until she's complied with that June order from Judge Hahn.
Your Honor, I have complied. If you look at my
Ms.
previous-
Peterson, I'll ask you to talk in a second. Okay. So 2 things. I think the oldest child is now 18. So there's no need to consider that individual in this case. He can do and go wherever I guess he chooses to go and do at this point. 2, there's been several records, and I think I would assume Ms. Height would be able to back me up on this, that frankly, this was a loophole that she didn't jump through, but she's been in ongoing treatment for almost a year at this point. So I guess I'm not really struck by that, and I don't know, frankly, it doesn't appear to me when I looked at the treatment records that there's a huge difference in what they're requesting that she do now versus what she's been doing. I'm happy to set it over 1 week, but I think that she should be in step 2, which is as far as I can read from Judge Hahn that, and I'm frankly pretty sure that it was specifically stated that the evaluation is what we were waiting on the last time we were in court. So and if there's more information that Mr. Peterson is concerned about and wants to be brought up. The last time we were here, the GAL said that the children were asking for a 50-50 plan. So I'm going to authorize the weekend, every other weekend. And that just obviously is with the youngest child now. As I stated, the other one has turned 18 since our last hearing.
All right, very good. Then we would ask that the court also set this over 1 week so that any other issues can be addressed.
That I'm perfectly happy to do that. So we'll set it to the 28th at 1.
Your Honor. Go ahead. Okay.
I don't know who started talking, so I, it's Peterson on
and
the site. Okay, go ahead.
And high starting ad item. I was just wondering if that was going to start this weekend, Your Honor.
Sure.
Thank you.
And then Ms. Peterson,
my
did you have
question.
anything? Oh, same question? Okay.
Yep.
All right, so we'll see you both back. Excuse me, the 28th at 1 p.m.
I have one more question. I apologize. Since it's starting this week and I'm scheduled with a visit with Lillian today, does that cancel it out, or is it the week and starts a whole new plan and I can still see her today? Does that make sense?
I don't think it has any effect on the visitation today unless you agree with Mr. Peterson to,
No, I want her.
okay.
Yeah, so
right.
Friday
And this is
7,
before
thank
the
you.
court on review on my motion to compel. As the court's aware, we
All
entered
right,
an order compelling discovery on January 19th that required husband to exchange discovery by December 9th. We were before your honor on January 31st, where the court extended the deadline until March and set a review to today. I received zero communication from husband since the last hearing and no discovery. I haven't entered it. There's been no notice of appearance from an attorney either. So I am inclined to ask the courts to enter an order of default. I do see that Mr. Van Tongeren is present in the courtroom today, so he can provide an update.
all right, Mr. Van Tongeren, if you have anything you'd like to say. Oh, hold on, you're muted. There should be a prompt to unmute.
There.
Okay, go ahead, sir.
Since the last Zoom meeting that we had, I have been trying to get an attorney, and the earliest date that I could get was next Wednesday, the 29th. So the attorney that I talked to has looked at all the filings and says that he is going to take my case, but I can't get in to see him until next Wednesday. So I'm asking a continuance so that I can be represented. I know this has been going on for a long time, but a lot of this time has not been me. It has been Donata also. And, you know, she lives in the house with me. I pay for everything. You know, I'm the only one working. So I think that I need to be representative before I have a judgment put against me that is not right. So I will have an attorney. Yes, I know this has been going on for a long time, but my side of the story hasn't been told, and quite a bit of Donata's declaration doesn't include a lot of things that it should. Some past payments that she got.
And at this point, I just need to object. There's nothing before
Yeah.
the court.
So here's my concern, Mr. Van Tongeren, is it appears as though for 4.5 months, Ms. Gilmore has been trying to get discovery from you. That's something that you can do without an attorney. And it appears as though that's been gone over with you, what is needed in review hearings in front of Judge Scudder, and you know what the issues are. The last order to compel, which was the second order to compel, was entered on January 19th by Judge Scudder, January 18th by Judge Scudder. And it shows that you didn't comply with the last order to compel, that you didn't show up for court on the review date for that order to compel, and that all discovery needed to be complete by January 31st. Then we had a review on January 31st, and I gave you until today, so another almost 2 months. So the court is, you know, defaults are not looked upon very kindly by Court of Appeals. It's something that I don't want to enter a default and then have it, there be a motion to, you know, to set aside that default because you have counsel. You have an appointment on the 29th, you said?
Yes.
All right, here's the deal I'm going to make with you. If you're here April 4th with an attorney, I won't enter a default.
April 4th.
If you're not here on April 4th with an attorney, then I am going to enter a default.
Okay.
And it asked the court to enter fees today. Asked the court reserved at the last hearing, given the failure to provide any sort of documentation or have any communication with me whatsoever. I think more fees are appropriate.
I'll impose $500 in fees today.
Thank you.
All right, so we'll see you on April 4th at 1
Your
p.m.
Honor, this is ever
April 4th at 1
evolving
p.m. Thank you.
case. Child is still in Mexico. We were very optimistic that he was coming home 2 weeks ago. Now there's been now a stay, and the Hague Convention is being followed through with, but the judge down in Mexico has requested that the order to release the child to the FBI to come home be done through the Hague Convention, where we were hoping that we would be able to get it just through the province that it's down there with currently. So we could go on and on with that, but to answer your question more succinctly, child is still there. We're still working on it. We're still asking that you basically renew the order that's in effect through Cowlitz County, and keeping our fingers crossed that Gael comes home sooner rather than later. Unfortunately, there is a lot of red tape down there, and we're navigating it as best we can, along with the FBI and the State Department and such. But we're still optimistic.
All right, that's better news than we had last time. So I'm glad to hear that. I will do a reissuance of the restraining order. Do you want to do another month review, or?
I would actually rather see it go 2 months out. The Hague Convention is tedious, to say the least. It's more cumbersome when it's in Mexico, who some provinces follow that more readily than others. And from what I understand from the FBI communications, we're in a province that kind of does their own thing. So that's might be problematic. So I would ask for 2 months. I think that's probably the soonest this child comes home, if we're fortunate, then we can review it at that time.
All right, how about May 23rd?
That works for me.
So I will, when we're finished up this afternoon, I will do a reissuance of that order and get it to the clerk's office with May 23rd as the date.
3808. We're on for
Thank you.
essentially a review of the interim order. The court ordered an interim order and then ordered sort of a GAL follow-up and a further hearing today to address that order prior to entering, I think, a more full temporary order. I'm not sure who you want to hear from first on that.
Well, you're unmuted and ready to go, so go ahead.
All right, very good. The guardian ad litem did file a sort of a, I don't know if you want to call it supplemental, but an interim report. I assume the court's had an opportunity to review that. We absolutely object to the recommendations made. If the court will recall, initially my client had Friday to Monday visits. Those were ratcheted back due to sort of the comfort of the children. And then also ratcheted back because my client didn't have housing. He had to leave the family home and was living with a relative. Since then, my client has obtained housing, and the recommendation is to further ratchet his time back. And we absolutely object. That's not appropriate. When you look at the guardian ad litem's interim report, there is no danger to the children whatsoever that she reports. There is no clinical levels of any sort of distress for the children that she reports. She's restricting or recommending a restriction on parenting time essentially because of the comfort of the children. But the reality is that it's going to be uncomfortable to make a change. That's always true for every child and every parenting plan, that when you go from a two-parent in the same household to parents being in separate households, and gee, that's not my bedroom and I'm not used to it, there's going to be some growing pains with that. There's going to be some discomfort with that. That is simply just not a basis to restrict my client's time. Further, when we think about what the children actually need, they need time with my client to be comfortable, to be able to be in his household, to make their own space, make their own routines, their own holidays and celebrations. They need that time. And the parenting time recommended doesn't even rate. It's not treating my client like a parent. It's not even treating him like a babysitter. It is just not sufficient time. My client wants to address, there's guardian ad litem says, hey, there's some inappropriate text messages from dad to mom. Again, those are from dad to mom. And my client says, yeah, he would say, I shouldn't have done that. To address that, he took the recommendation of taking the children in between class and took it a step further and took the high conflict parenting class. So essentially it's double the length of time of the class recommended by the guardian ad litem. We're filing that certificate if it hasn't been filed already. So again, my client wants to address that issue like right up front, isn't going to sort of try to avoid. And he's done that throughout. The court will remember the guidelines, said, gee, dad was very compliant. He wanted to do what's in the children's best interest, always wanted to sort of defer towards doing things that are going to be good for the children. But he can't do that when the recommendation isn't in their best interest and isn't what is good for them. Children make statements such as, I miss my dad. So again, an indication that the children need time with my client. My client was heavily involved in the children's lives prior to the separation, wants to continue the relationship. And a lot of the sort of the guideline talks about like the pressures of the phone calls, because my client is desperate to maintain their connection. So he's trying to maintain that connection. And because they doesn't have sufficient time, the only way he can do that is really through phone calls and texts and trying to grab on to whatever is available to him. So we're in a situation where my client's being limited really without any kind of basis. And so at this point, he's obtained housing. He's taken the class recommended by the guardian ad litem. We should return to the original temporary order, which was Friday to Monday, that on alternating weeks. That has several advantages. First, it maintains dad's connection with the children's schools. It also prevents any contact between the parties. I would certainly argue that there's high conflict on both sides of this case, given mother's allegations that even law enforcement didn't believe. So again, avoiding contact between the parties is good. It allows the children to relax into both households. Additionally, my client should have the standard holiday visitations, 3-day weekends should attach, half a spring break, and a reasonable summer visit. So a reasonable summer visit would be at least 1 week out of every month, June, July, and August. In addition to regular time, mother should also have dedicated summertime as well. Talking about calls and texts, those are a little bit challenging for children to manage. What I would say is that at a minimum, there should be at least 2 calls per week that are dedicated times where dad talks to children. Children can determine the length of the call. If it's short, it's short. If it's long, it's long. But that there's a dedicated time that relieves the pressure of the children, but also ensures that there's continuing contact. Because if my client's only seeing them on sort of an every other weekend basis, there should be time in between. And that's especially true if the court isn't inclined to order a midweek visit, which is fairly traditional, such as Wednesday from after school till sort of after dinner time. Children and my client should be free to text. There just shouldn't be an obligation for either side to respond in addition to the calls. These are a little bit older children. They know how to use technology. They should be free to use that to engage the father as they desire. But we should have dedicated times. I think that that'll alleviate any sort of pressure. But again, that only comes when we're having real visits with father. He's addressed the deficits. He's doing everything the court has asked. There's no basis to restrict, especially this heavily handedly.
And in the original temporary from December of last year, it has weekends 1st and 3rd, Friday after school till Monday at school. It doesn't have a midweek visit. Was that something you were asking in addition then? Since it wasn't in that, or?
I think that it's appropriate at a minimum on the off weeks to have it, just so that there's that continuing contact, that dad's seeing them at least once a week. He can pick up from school. That results in one contact between the parents or one exchange that happens directly. But these are not infant children. These are children that can certainly transport themselves between the curbside and a house.
Okay. Thank you. Ms. McLean.
Yes, Your Honor. So you have referred back to the temporary parenting plan that was entered back on December 16th. In the interim, we also had the guardian ad litem interim review that was entered on February 2nd, 2023. That was as a result of our hearing in January. And so currently, Mr. Kaufman's visitation is every 1st and 3rd Sunday for 8 hours from 10 a.m. to 6 p.m. and every 2nd and 4th Wednesday from after school or 3 p.m. if there's no school to 7 p.m. So that's what the current visitation provision calls for. I guess initially I would say I'm a little bit concerned that this is turning into a potential free-for-all by Mr. Kaufman as it relates to the parenting plan. And I think that the court should take into consideration the information that we did receive from Ms. Height. Ms. Height does acknowledge that Paige, actually both children continue to be remain in counseling, that Paige, her diagnosis has gone from separation anxiety since early childhood because of her connection with mom, to now generalized anxiety. Both girls talked about their anxious feelings because of father's direct involvement of them, exposing them to ongoing conflict. And even since he's been in his new housing with his father's involvement of making derogatory comments about the mother in front of them. Those are all in violation of the provisions in the temporary parenting plan that remain intact in regards to how to appropriately communicate with the children. So even since this interim order has been entered, reducing his time, and despite the court admonishing him at the hearing, and I believe that that's also outlined within your order, it talks specifically at paragraph 6A5, Justin Kaufman shall be allowed to attend public events for the children so long as his behavior is appropriate. And then paragraph 4 also indicates that you had concerns about Justin Kaufman's general disposition towards Rachel Kaufman in regards to the language he uses in text messages and his behavior during visitation exchanges, and that he shall be appropriate in all of his communications and contacts with my client moving forward. Couple that again with the no derogatory language and not involving the children in the litigation. And since that order has been entered, as I read Ms. Height's report, he's continuing to engage in the same behavior, and this is causing the children distress. So the suggestion that Ms. Height didn't make any findings that the children are affected, I think is contrary to the actual words and the language that Ms. Height uses within her report. So our concern is that during the visits, the children continue to be exposed to toxic comments about mom. They're able to parrot the information that their mothers commonly referred to as trash by Mr. Kaufman. That both children have described to Ms. Height how they have changed their behavior and their mannerisms in order to thwart negative discussions with their father and in order to thwart setting him off due to his anger. That in and of itself suggests that, again, Mr. Kaufman needs some anger management and or domestic violence training. And to be quite honest, given the disclosures by the children to Ms. Height, I'm amazed that she didn't at least make those recommendations. The information from Paige's counselor shows that there has been a long history of toxicity, conflict, and abuse that has been exposed, that Paige in particular has been exposed to, that's been directed both at the children, in front of the children, and towards their mother. This is chronic in nature, and that's why we have these long-term diagnoses for Paige, who's the oldest. You have Paige who's describing to Ms. Height about feeling guilty because she feels like she has to oversee or protect her younger sister during visitation. This is not the epitome of a healthy child parenting relationship. And the bald assertion that Mr. Kaufman has been a primary parent, quite frankly, is laughable in light of all of the evidence that has been provided to Ms. Height thus far. So if anything, it's our position that the court follow Ms. Height's recommendations. The fact that the girls are even expressing anxiety over telephone calls and not wanting to talk to him, and him making them feel guilty about their self-protection and not wanting to be exposed to just that limited anxiety trigger for them, again, does not take into consideration the children's best interest. He's in it for himself. He doesn't care. He's a self-gratifying adult male who is going to do it his own way. But these children need to have the opportunity to be heard, and their mouthpiece here is Ms. Height. So we're asking the court to adopt Ms. Height's recommendations. We would propose that the court provide for visits the first and third Sunday, so we'd keep those Sundays in place from 10 a.m. to 6 p.m. I think we do need to include language that third parties are not to be present, particularly his father is not to be present, because clearly he can't control his mouth and his vitriol towards the mother of his grandchildren. So they need to be protected. We agree that on non-Sunday visits, there should be a telephone call from Mr. Kaufman to the girls. If they decide that they want to answer and talk to him, it can be up to 15 minutes as she recommends, or whenever the children terminate, if it's prior to that. And we don't have an objection to every Wednesday for a phone call. Again, if the children engage in that. Quite frankly, we think that it should be self-directed by the children. If there's anything that's going to foster an appropriate relationship with the children, it should be self-directed, and there's no indication that my client has in any way interfered with the children's ability to self-direct phone calls to their father. But if you're going to order phone visits, then we'd say the non-Sunday visitation days and every Wednesday at 7 p.m. So that would be our proposal. Quite frankly, we think that Mr. Kaufman needs to engage in anger management. He probably needs to engage in some parenting classes and or domestic violence treatment, evaluation and treatment with collateral input.
Oh, you're muted, Your Honor.
Thanks. Ms. Height, I guess I want to clarify something because I don't know that it's clear. There is you referred to on page 3 of your report, a lengthy record of inappropriate text messaging between the parties. Is that recent? I mean, is it still ongoing or that you're aware of, or is this prior to the orders that were entered at the beginning of February? If you don't know, that's fine too.
I don't know right now. I remember looking at the dates, but I can't definitively say right now, Your Honor. I'm sorry. Well, I would just clarify that. A great deal of the conversation was about the sale of the home, which is just, I believe, just been accomplished. So some of the texting was concerning the home sale. So that would indicate from my memory that it is, at least during that time, ongoing, that it's been recent since their separation. And it was quite extensive.
Thank you. Anything else from either party?
So just in rebuttal, I think the guardian ad litem's report says dad's household is safe and he is not abusive. Period. You can't restrict someone to 12 hours, which is what is being proposed, a month with that report. You just don't get there. There's no 191 factors that have been found. This is not a free-for-all. The court specifically sort of put a pause on that original temporary order, said, we're going to ratchet back for a little bit, and then we'll come back. And that's where we are. I'll note that there's no statements that grandfather is saying anything. The child statements or the guardian ad litem says the children feel that they're being judged, but not that anything is being said. And again, these are things that happen when you don't have enough time around people to actually communicate with them and spend time with them and be a family. And that's what's happening in this case. My client is actively addressing anything the guardian ad litem brought up, even before this hearing today. Again, we're in a position where, similarly to Your Honor's question, it's like, well, statements to the children, there's no dates on those. So my client has now taken those parenting education classes that the court would want to see. But again, we're in a position where these children need time with their father. It needs to be a reasonable amount of time.
Your Honor, might I respond?
Sure.
I essentially stand by my report, and I understand it's a temporary report and that we'll be back for a full report in about 6 weeks. And I understand that it is frustrating for dad to make a phone call to a child who doesn't want to talk to him. The whole situation, I understand, is frustrating. He has clearly stated to me that he wants what's in the best interest of his children, and I really, truly believe that. However, things are not going well. When I see the kids, the last time I saw them, there was a noticeable difference. I saw each of them at their school. They were both noticeably distressed. They, in the way they responded, it just seems like they are wearing down. There is a toll being taken on both of them for whatever is going on. Some of it is undoubtedly just the length of time this has gone on, but they feel, I think, a sense of concern and even a sense of responsibility to a degree for what's gone on. And I believe that's stuff that needs to be and is being addressed by counseling. I would state that grandfather has made disparaging remarks. I have those specifically. I did not include them in this brief report. I have those for the next report. Grandfather has been disparaging toward mother, at least to the older child. I'm not so sure about the younger one. They do not want, they have clearly stated that at this time they do not want to spend overnights. And I let them know that I don't make that decision, but that I would carry that message clearly to the court, and that was someone else's, another grown-up was going to make that decision. Again, I stand by my report. I understand the frustration. I would also note that this is still in the temporary state, and there will be a further report forthcoming for the May 5th hearing.
And Ms. Height, just to follow up, when was the last time you met with the children? I mean, how recently was that last meeting?
It was the first part of this month.
So a couple weeks ago.
Yeah, within the last couple of weeks.
Okay.
On the 6th, I met them with them on March the 6th separately.
So they were already 5 weeks into the reduced plan and still were not doing well?
Yes.
Okay. Does any of that input, I guess, Ms. Baldwin or Ms. McLean, if you have any questions for Ms. Height, or if you want to add anything else, given my questions to her and her input?
No, I'm fine with what she's reported.
Anything else, Ms. Baldwin?
Only that you've reduced the time and it's not working. It's not better. And so that indicates that what we're doing is not working.
So this is not a great situation. I will say very directly to Mr. Kaufman, the type of comments that are recorded that you make towards Ms. Kaufman are reprehensible. They're not appropriate. You're raising 2 daughters. So you're raising 2 young women and you're talking about another woman that is their mother in those terms. And that is wholly inappropriate. And I am a little bit baffled. And I'm going to assume that it hasn't continued since the last time we've talked about this, but it also, you should be responsible for the folks that your children are around. So it shouldn't happen with them either, or you should take immediate action of that. I'm glad to hear that there's a parenting plan, or excuse me, a parenting class. And Ms. Baldwin, you did refer to it being filed. It is in the file. So I did see it in Odyssey, the children in between certificate. So that has been filed. So I do appreciate that. Overnights arguably weren't working. No overnights, arguably not working. Frankly, I feel that the children are in this situation. The fact that it's up to a third party that gets to hear snippets is probably frustrating for everyone. It's frustrating for me, and that I make the decision based on what I have here. I absolutely do want to take the children's best interest to heart. And frankly, I don't know what that is now, except for cutting out dad entirely. And that's also not appropriate to do. There are no 191 factors. The order that we were hoping to return to after this break for the last month and a half, almost 2 months, is the December 16th. Thank you. December 16th order, which is the first and third weekends from Friday after school to Monday at school. I haven't seen, other than the GAL's input, and please correct me if I'm wrong, but I haven't seen any information from counselors about the detriment of overnights away from mom, other than just what the kids are vocalizing. So I'm kind of do something a little bit different. I'm going to do at this point in time, we're going to go partially back to the initial parenting plan. And so all the admonitions are still in place. We're still, so I'm not going to change anything until we get to section 8. B1. So what I'm going to do is I'm going to authorize a return to weekends, but it's going to be from Saturday at 10 a.m. to Sunday at 6 p.m. So it'll be one overnight on the 1st and the 3rd. I think on off weeks, 2 phone calls are appropriate for the children to determine the length of those phone calls. And I'm not going to order that they phone their father twice a week. But I don't think dad should attempt contact with them more than twice per week. And if they aren't engaging in those phone calls, there should be no retaliation, comments, requests for any other accommodations. These are young kids that are working their way through an adult situation. And a lot of deference needs to be paid to them. And again, no comments about either parent in front of the children. Don't let other people do that. We need to figure out something that's going to work. And at this point in time, I understand the children's concerns. I understand the parties' concerns, but I don't think we're at a point where we can give up on the idea that dad can be a parent to these children in the same way mom has been. So everything else should stay the same. It looks like Fred Meyer is the exchange location. So I'm not going to change really anything else other than what the weekends are defined as.
Your Honor.
Yes.
It's my understanding that the grandfather lives with them part-time, lives with Mr. Kaufman part-time. Are you expecting that he would not be there during the time of their visitation with dad from Saturday into Sunday?
I guess the council want to weigh in on that.
That would be our preference. I mean, clearly he's an adult, he should know better. And Mr. Kaufman didn't step in to stop him, and that has occurred since our last hearing, because he had just moved in with his father when we were at our last hearing, I believe. So we would ask that the paternal grandfather not be present. They need to focus on their relationship with dad, and he needs to focus on his relationship with them.
So my client's in the position where he can't independently afford housing. The court will recall there are very, very significant financial obligations put on my client. And so he's living with someone else as a result of that. Requiring essentially my client's roommate to move out is very difficult. And that person then has to find somewhere else to stay. And if they don't, then what happens to my client's visit? So I'd ask the court not make that prohibition. My client understands the court's order on grandfather's statements. I don't know that my client even knew that those had happened prior to the guardian ad litem statements today. If something happens outside of your presence, even if you're in the home and you don't know about it, that can be very challenging. So I'm asking the court not to order that. That's certainly something that we can review at the final guardian ad litem report.
Your Honor, my understanding is that father or grandfather lives there only part-time.
And I don't have that information.
And my understanding,
go ahead.
And my understanding was that father was present when grandfather was making those statements.
I don't have that information, and it's not in the guardian ad litem report.
Yeah, I don't know that information either. Here's what I'm going to do. And I can't believe how many times I say this. I'm going to expect adults to act like adults and be responsible for their comments and actions in front of children. If for any reason whatsoever, between now and our next review, any party has information about grandfather acting inappropriately, saying inappropriate comments, I want to hear it. I want to hear it. But at this point in time, I other than the comment in the GAL report, which, I mean, I would presume dad was around. I can't presume that he was aware of the comment, and I'm not going to presume that. But this is the fair warning. Anything beyond today that's said in front of the children disparaging anyone associated with the family is going to be dealt with appropriately. So I'm not going to make that order at this point. My hope would be Dad takes that time to spend with kids as much as possible, just the three of them.
May I ask a clarifying question?
Sure.
So you first indicated off weeks are for 2 phone calls. What are you defining as the off week? Is that the week after his visitation weekend or the week before his week?
Yeah, I would say, I guess the second, fourth, and fifth weeks.
Okay. Okay.
And also, I believe, and please correct me if I'm wrong, but I think are the kids involved in sports, correct? So I would hope
yes,
that there would be some communication if there's places they need to be and activities they need to be involved in those weekends, that they wouldn't, that whomever has them make sure that they're able to participate in those.
So I'd ask the court to change that slightly because it seems like we're just creating a land of contempt for somebody misreading a calendar. I'd rather my client just have a weekly call that's just once a week. And then that way it's not, oh, you called on the 3rd week, now you're in contempt. It's easy if it's better and more straightforward if it's just every Wednesday. That my concern is just creating a land of contempt where none needs to exist.
So instead of 2 calls on 3 weeks of the month, 1 call every week, that's fine. I don't have a problem with that.
So Wednesdays at 7?
That's fine, so long as it doesn't interfere with kids' activities.
Okay.
And then I'm also asking to clarify, because these are a little bit older children, they're involved in sports and activities. If Dad goes and watches the choir concert, can he text, hey, good job? And would that be a violation?
I don't think any positive support should be considered a violation. And then it's up to the girls if they want to respond to any of that. Okay. And if it's an agreed order, or if there's an email that needs to be circulated, that we can get that order entered sooner, I'm happy to do that, but we'll set it for the 18th for presentation. And if we get it entered, we can strike it.
Okay, thank you very
And
much.
then it looks like we have a final review on the May 9th. So that'll stay on the calendar.
Okay.
All right. Thank you. Good luck.
And I sent an email to the court. Did you happen to see that by chance?
I did.
Okay, so we are agreed, excuse me, on, we're asking you to make that interlineation at paragraph 4B3 to include the words mental health before the word service. Ongoing counseling participation and mental health service records. I didn't mean to imply his military service records. Paragraph, thanks, at paragraph 10, on the language that's associated, excuse me, with the Martin Luther King Jr. Day, President's Day, Memorial Day, if you just strike that language as far as the definition and indicate reserved for guardian or GAL input. And the same for spring break. At paragraph 11, if you change A to read, if you'll strike children or child's birthdays and say named holidays, and then it'll read named holidays shall be followed before, and then take out named holidays and, so it'll read named holidays shall be followed before school breaks. So at 3B1A, that was part of my proposed order based upon the guardian ad litem's recommendation. That wasn't actually argued at the time of the last hearing. And you were working off of my proposed order when you were making your rulings. So my argument is that that language should remain.
And Your Honor, our response to that is that the court has never made any findings of neglect on the part of Mr. Gilman. The guardian ad litem report, she says she had concerns about possible neglect by Mr. Gilman because he was focusing too much on gaming, while not immediately engaged with the child, and because he was sleeping deeply. Mr. Gilman stated in his declaration that he took that concern to heart. There's been some changes made there. The guardian ad litem can certainly look into this again if necessary, but there's never been a finding of neglect on Mr. Gilman's part, and we don't think it's appropriate to include that.
I'm going to reserve on the 3B. And I've indicated that on the order.
The entirety of 3B.
Yes.
Okay. And then the next issue is paragraph 4A2, and this is the firearm language. I saw Ms. Dow's objection, and in our discussion behind the scenes, the way I read that is that he's basically allowed to secure firearms. The court's intention was that he was not to have possession or access to firearms or other weapons during his residential time. And we talked about him securing those either in his sister's household, looking at lodging those firearms that had come from his grandfather or some other third party with Gator's guns. And I believe that my language is appropriate for purposes of enforcement. Obviously, the whole point is to remove firearms from his and his child's immediate access or possession during his residential time, given what occurred in December this last year. So I guess the only other alternate language would be to say that he cannot access, possess, have in his custody or control, purchase, receive, or attempt to purchase or receive firearms, ammunition, or other dangerous weapons during his residential time. And that's just parroted from patterned language on firearms restrictions. But again, the language that I've proposed is relatively consistent with what historically the court has adopted in prohibiting or enjoining and restraining the possession or having access to the firearms. So I guess I would stand by my proposed language.
And Your Honor, the event in December, it's understandable that Ms. Gilman would have some concerns about that, but that was also the trigger for some so far effective mental health counseling and treatment for Mr. Gilman. He has not had these sorts of issues since he's begun participating in that Wounded Warriors program. Language restricting access to firearms by Mr. Gilman. Our objection this week is the same as it was last week. Ordering a periodic restriction on access to firearms by Mr. Gilman, it's not realistically enforceable. Any offsite storage is going to be voluntary. It's not by order of the court. It's not going to the sheriff's office. There's no restraining orders in place. There's no evidence before the court to bar Mr. Gilman from owning or having access to firearms. The court did direct Mr. Gilman to make sure that firearms are locked up. That's the minimum common sense, and he agrees with that. He's got a locker that any handguns will fit into and be locked up while the child is there. It was suggested that he look at offsite storage for guns that he doesn't have any storage for, and he is fine with doing that. But again, he's got lockable storage for some of the guns. He can voluntarily store them offsite for the guns that are, overflow. There's no grounds for restricting his access to firearms on a periodic basis. And it's not really realistic because, again, as I said, any offsite storage is going to be voluntary. There's nothing to say that he can't go and get one. So we're asking that language be struck and that our proposed language be adopted.
And I guess I would just remind the court from your ruling last week, you indicated that you were concerned for the safety of all parties, that section 4A2 is appropriate. Firearms and ammo needs to be secured in the home with the sister and brother-in-law during visitation.
And whether that's, I don't know if there's a safe in the home that any kind of firearms, ammunitions, or other weapons can be secured in the home with sister and brother-in-law. That's probably a good idea, period, but especially during any time with the child.
So he's not to possess or access. So is he able to lock those up in his sister and brother-in-law's gun safe that he doesn't have access to?
He would have to take his separate locking safe and put it in the house. And let me just clarify, are we talking about access to guns during his parenting time, which is what you put in your motion, or are we talking about no access to guns whatsoever? I mean, moving a little further down the road.
My order is just during parenting time, excuse me. So I don't, I guess without knowing the number of firearms that we're actually referring to here and what kind of difficulty this is, long story short, I don't want him or the child to have easy access to firearms when they're together. And so if that is in a safe in the home that he has access to, you know, when the child's not there, that's fine. I'm not ordering that he never have firearms, period. It's just, they need to be locked up. And if that's in the tiny house on the property, as long as they're in a safe, that's fine. As long as they're locked up and the child doesn't have access to them either.
Asked us to work out the language parameters. So again, I think that with the suggestion that you wanted some additional language in there, I think that this provides for the court's intent.
He could move his own gun safe into the main house.
He doesn't need to move his gun safe. I want the firearms locked up when the child is with father. Wherever that is, as long as they're locked up. So yes, arguably he could access those firearms if he unlocks the safe. But as part of the court order, I'm saying that he not be restrained from possessing those outside of the safe during the time with the child. So here's what I'm going to say. The father shall be restrained from possessing or having access to firearm, ammunitions, or other weapons during residential time with the minor child. They shall be secured such that the father has no access. So they shall be secured during residential time with the minor child, including looking into placing the firearms with Gator's gun and Kelso pending further order to court. So I'm just going to note here. So I struck those a few words in there, and then I added firearms shall be placed in a safe while the child is with father. Right?
So the question is whether or not to add the language about neither parent shall interfere in the parenting style of the other, nor shall either parent make plans or arrangements that would impinge upon the other parent's authority or time with the child without the express agreement of the other. Each parent shall encourage the child to discuss their grievances against a parent directly with the parent in question. It's in the intent to encourage a direct parent-child bond and communication. That language was in the prior parenting plan. I would argue that is sort of feel-good language. The question is whether or not or how you enforce that, and whether or not that's just potential fodder for ongoing conflict.
And Your Honor, our position here is that we're seeing a developing pattern of the child saying things to mom and to mom's relatives that directly relate to things she doesn't like about dad. We would ask that the court include that language or some language like that, that makes it clear, at least to both parents, that the child should be encouraged to talk to the parent that they're having a problem with. Don't just complain to mom or grandma, talk to the parent you're having a problem with so that they can address it.
And I would suggest to the court that if you recall back to the declarations from both my client and her mother, and I believe her sister, all acknowledge that when Freya was having difficulties and hiding behind the furniture, that they were encouraging her, and that she and the father sat on the front porch to resolve those issues. So to suggest that there's some pattern that my client is inappropriately involving the child, I think those declarations show that in fact, my client and her extended family are acting appropriately so that Freya and her father can address those issues.
I think I'm going to ask Ms. Dow a secondary question. Is there the neither parent shall interfere in parenting styles and impinge on parents' authority or time by making other arrangements? Is that an ongoing issue?
That does not appear to be an ongoing issue at this point. This parenting plan is evolving.
I'm not inclined to include that language. However, I do want to say that the child should be encouraged to have free discussions with both parents. I do recall the prior declarations. I do have notes on the last hearing. If that becomes if there's a showing that becomes an issue, then I'm more than happy to reconsider including that language back in. But at this point, I'm going to leave the paragraph 14 as proposed.
Thank you very much, Sharon. Okay.
Thank
And
you.
then Ms. Dow, is okay if I just say approved via Zoom?
Yes, Your Honor, that's fine.
Thank you very much. And then I'll get this to the clerk when we're done.
Thank you.
All right, thank you, Your Honor.
Yes, we have show cause contempt, motion to compel,
And motion for relief.
and a motion for relief.
Very good. And so again, for the record, I represent Cameron Gibson, who's the petitioner in this matter. I'll address the compel first. It's most straightforward. Discovery in this matter has been pending since 2021. We are now in 2023. The responses that were received quite a long time ago were will supplement. They were never supplemented. We went through the rigmarole of doing ACR 26I. Timeline was chosen not by me for responses, but by opposing counsel. We received just a handful of documents from the many that needed to be actually provided. We provided a list, a detailed list and letter. Again, we're in a position where really nothing more has been provided since that initial sort of couple of documents that were provided after the 26I. We've made efforts. We're just not getting anywhere. We filed a motion to compel. We are asking for the court to order her to provide the materials as indicated in the letter that's attached to the motion. I'm asking for fees of $1,125. And I'm asking that the court set it out 2 to 3 weeks. I guess I've inclined towards 3 weeks. We can do a presentation at that time, and then we can also address compliance. We are rolling towards a trial. We do need to have these documents provided so we can appropriately do that. Does the court want me to just go through each of the motions, or do you want to rule on them one at a time?
Hold on. Okay, so and I just want to make sure that I'm following along. So if you have Odyssey up, index 160 is, and then that attachment A is the list that's still outstanding. Is that correct?
So we don't have index numbers on our side of
Oh,
Odyssey.
sorry.
Unless I pull up each document.
It's titled motion to compel, and it's a 6-page. So and it's the exhibit A, and it looks like it's a letter to Rory Flay on February 7th, and then posts CR 26I, and then the list of a page and a half of. So that's what we're still missing.
That's correct.
Okay.
Other than we did get a few items but those were identified in the motion specifically on what we received. That was like the 2021 tax return, and I think her wage stubs.
Okay. All right. So I think will be easier to just deal with these one at a time. So Ms. Gibson, any response to the motion to compel?
Yes, Your Honor. Thank you. So that first discovery request was done in October of 2021. I did have counsel at the time who did fill that out, obviously with some of my stuff. I didn't understand, or I guess I wasn't aware that I needed to freely supplement that information from Ms. Baldwin. And I didn't find out about any of it until I briefly had counsel this last month in February. Per my conversation with my counsel, I supplied the wage stubs and the tax return information because that is what he relayed to me was due at the time to Ms. Baldwin. It wasn't until afterward that after he withdrew on February 14th or February 15th, I believe, that I received that document that listed those 26 or 27 outstanding supplementations. So I have been working to compile those and get those for Ms. Baldwin, having 26 or 27 different things to look through and gather, and having to re-reference my the first discovery response to know what exactly I need to include and update is very time consuming. And I haven't not complied. I've been trying. The apparent deadline for when she had contact with counsel came and passed. And after that February date, after that week due date passed, I didn't receive any word from Ms. Baldwin relating to not having submitted what apparently was agreed by my counsel that I was going to submit. The only notification that I received about this was the motion that was filed 2 weeks later. Had she reached out and had I known that that was what she needed, I would have worked with her to get what was requested of me. And I've been working to supply all of it and get it all put together for her. As I said, there are over 26 different supplementations to get through. And so I would ask the court to have additional time to complete the request and work with Ms. Baldwin to get that over to her. I just, as I said, the only, I guess, contact that I received from her after this conversation that she had with my counsel was the filing of this motion. Had she reached out to me prior to that, but after my attorney's withdrawal, I would have been more than happy to work with her to try and get it resolved, but I didn't receive anything as such. I didn't realize that all of those things were outstanding and needed to be given to her. And so I'm asking the court to allow me additional time to compile everything so I can be compliant with her request. I'm also asking that they not award any attorney fees or expenses at this time. As I said, my attorney withdrew on February 15th, and this was filed, I believe, the 26th or 27th after that. So there were 2 weeks that at any time Ms. Baldwin could have reached out to me to let me know that I hadn't given that information to her. And instead I received this motion.
Very briefly. Oh, go ahead.
I'm just going to ask one question here. So, Ms. Gibson, how long do you think it would take you to complete the requests for these supplements?
I mean, I'm going through them as each one, so I haven't looked at the list in its entirety to see what all is needed. I've been going through each one and getting everything. So I would ask if I could have, an additional 6 to 8 weeks just to make sure I get absolutely everything to Ms. Baldwin. That way we don't have to come back in front of Your Honor if I get something to her in haste and unintentionally forget something that was requested. I don't want to come back in front of you for that reason. So I would ask for that time to be able to get everything to her in its entirety.
Okay, Ms. Baldwin.
Thank you. She's provided a letter. She kind of keeps repeating saying, like, I didn't know. A, she had counsel. B, from the get-go, she put will supplement, which is a statement that you will do something, and she has not done it. C, she's not done anything since getting the motion. Her entire statement is, I want to continue to delay, and I'm going to go through the list one at a time and not look at the whole. Ms. Gibson is not uneducated, not incapable. This is a delay and a stall. And so these have been outstanding for a long time. She doesn't need 8 weeks. The court should set a reasonable amount of time, but they're supposed to be answered in 30 days. There's not even statements that she's ordered things and they're on their way. It's just, again, a delay. So the court should order materials to be provided. I'm suggesting 3 weeks. That's very reasonable. Fees are appropriate. We've made efforts to try to get these materials, and she's just not responding.
Your Honor, if I may.
Briefly.
Okay. I spent the majority of 2022 without counsel. If Ms. Baldwin really wanted these documents, as she's now stating that she does, she could have requested them from me. Again, when I had counsel, when I filled these out, I was told that it's standard when you don't have the documents to say that you'll supplement them, and then opposing counsel will ask for those documents at a later date. So it's not that I've been sitting on it since December of 2021, not doing it. It was relayed to me that counsel would ask for it at a certain point. And I was without counsel for the majority of last year. Ms. Baldwin could have reached out to me at any time requesting that documentation so I could continue to work on it. And she, for whatever reason, decided not to, chose not to. I don't want to speak for her, but
Have you reached out to her at all? Have you reached out to her at all?
Regarding
the case?
Regarding this specific documentation?
No, the case.
Yes, I've reached out to her. I'm sorry?
I said, okay.
Yes, I've reached out to her. Oh, okay.
No, you can keep going. That was just my response, was okay.
Oh, okay. Yeah. So that's all I'm going to say on that is it's not me intentionally since December 2021 not supplying things to her. She could have just as easily reached out to me requesting that documentation. If she had chosen to earlier, I would have done and gotten it to her sooner. I just found out about this when she filed this motion. So I just ask for more time and to not award fees and expenses at this point, because I feel like this could have been resolved outside of having to appear in front of Your Honor.
So I'm going to grant the motion to compel. I'm going to reserve on fees to the review date, which I'm going to set. So assuming everything gets completed by then, that will determine whether I impose fees. How about, does April 18th or April 25th?
Either date should work for me.
All right, April 18th. So that's another 4 weeks to get that supplemental information in.
Well, can we have her provide it by the 11th? And then that way I can compile it and then submit something that says, this is what we have and this is what we don't have.
Sure, let's do this then. Let's have everything due by the 18th of April. And we'll review it on the 25th of April.
Okay, very good.
And I'll reserve fees until that date. And reconsider at that point in time.
Okay.
All right, then let's move on to the next.
So the contempt is pretty straightforward. We can handle that one next.
Okay.
So in this case, the contempt is somewhat side by side with the withholding of information. 2021 court order parties to file their 2021 taxes, and that the refund was supposed to be placed in an attorney's trust account. My client did what he was supposed to do, clicked the 2 buttons, DocuSign, tax return gets filed. All of a sudden he doesn't have it. Wife gets the money and he doesn't know where it is. He never even knows sort of that this happened until we received the 1 or 2 documents from opposing counsel earlier this year. At that point, we realized that a refund had been issued. My client says, hey, where's the refund? And that's essentially the contempt, is that refund was supposed to be placed into a trust account. It never was. My client didn't agree to splitting it. And even if Ms. Gibson sort of said that's her, she says, well, we agreed to split it. Like, well, if that was true, why didn't she disclose that she received it, how much she received, and give my client his half? So her statement that, well, I believe we had an agreement, really clearly falls flat, because if she did, then she didn't follow the own agreement that she says existed. Again, we still don't even know where those funds were kept. After this motion was filed for contempt, she says, well, what if I pay you, your half? We said, great, like, let's just resolve, how much you owe. But that doesn't resolve the contempt. And that, again, we don't know where she held it. She had the access to those funds for an extended period of time. She doesn't provide any documentation in her response to the contempt on where the money was kept, what happened to it, if she just spent it. And these are different funds that she's now using to pay him back. So again, pretty straightforward. And we're just simply, at this point, my client has received his half of the tax return. So we're just asking for fees and costs. Those are appropriately, I put $1,585 and a sanction, just $100 sanction. The fees include ex parte fee and service fee. And so that would be our request. Again, just really straightforward. And you see my emails of trying to obtain compliance prior, sort of really no response to those. So straightforward, we're asking for contempt. She knew where the money was supposed to go and just kept it herself.
Right, Ms. Gibson.
Thank you, Your Honor. I don't believe that I am in contempt regarding the 2021 tax return. There's been no willful violation or bad faith on my part. I've been trying to get petitioner his half of the tax return since it was received. Back when the court ordered that we needed to file it jointly, we filed it with the same accounting firm that has filed our tax return for the entirety of our relationship, which is local here in Cowlitz County. We docu-signed that document each individually. When you docu-sign a document, after it's completed by all parties, you automatically receive an electronic copy of what you signed. So for petitioner to say that he never got a copy of it and he didn't know how much the return was or where it went, it was in that document that he received. I called the accounting firm and got the DocuSign log showing when you open, who opens it, who does what, which I attached as Exhibit A in my responsive declaration, that shows that he reviewed and received it on or around August 1st. DocuSigning a tax return is not just you log in with your email and you're given access. You have to provide your social security number. You have to provide address information. It prompts you and asks you questions about previous places you've lived, previous relatives, things like that to confirm your identity so you can sign it. So for him to say that he didn't know what happened to it or where it went, just, it isn't true. He received it from the log. He had equal access to this document that I did. I don't understand why it's solely my responsibility to have access and get his counsel a document that he had access to. I even gave an example in my responsive declaration. He could have simply called the firm. He could have called the accounting firm to get a copy of the return, and I'm sure they would have gladly given it to him since his name is on it. I don't understand why it's my responsibility to do something when he could have simply made a phone call to obtain the information. Which the couple of times that I had counsel, I did address it with them. And I explained that, and they said, well, he'll get it to his attorney. And I said, okay, so that's why I didn't do anything with it. Petitioner and I did agree in a series of texts when we had to file this that we were just going to split the return. I attached one as Exhibit B, stating that, you know, he agreed that we would split it 50-50, get everything done. And that was on June 23rd of 22. I even attempted to get petitioner to give his accounting information to the accounting firm so that he could just directly get his half of the tax return. Exhibit C shows I even went so far as to screenshot the contact information for the person who supplied our tax return, had her name, had her phone number, has her email, has the address of the location, for him to give his routing and accounting information so he could directly receive his half of the return. He chose not to provide any of that information, so they went off of all the information that they had, which is that the return ended up in my bank account as it had for every single year that we filed our taxes together prior to this divorce. He then sent me a text on June 28th of 2022 where he indicated again that we would split it 50-50 and that his attorney, Ms. Baldwin, would be sending an agreement for me to sign relating to the half of the return. I sent a response email to her on June 30th because she wanted to see the text. I provided that texting information to her and said, you know, hey, I'll sign the agreement, or if he wants to provide his half, he can get the return. I received no response on that email. So I felt like I couldn't move forward without speaking to his attorney since he had counsel or continues to have counsel. I felt that I couldn't move forward without any recognition or response from her for fear of getting in trouble with the court. And so I didn't hear anything regarding the tax return until this year in January, when I briefly renewed counsel. He stated that I needed to provide the tax return information through the discovery request, which I did. I didn't hide any financial evidence. The document, as I've stated, was available to both of us. He could have easily called and obtained a copy. He was given an electronic copy of the document once everyone signed it, which states the amount of the return and the account and routing information where the return was placed. And it wasn't until I was able to speak with Ms. Baldwin on March 6th of this year that I was able to get an indication from her that if I got him his half of the tax return, we would be done. I've been trying to do this since June, and I either would get response from petitioner that yes, we would do it, and then nothing, or yes, we would do it, my attorney's going to draft something, I reach out to her, and then I don't get any response about it.
Okay, hold on one second. Hold on one second.
Yes, ma'am.
Ms. Baldwin, was there some kind of temporary order or anything that indicated this is what the parties are to do with 2021 taxes?
Yes, that's what the contempt is based on. So
Okay.
they were required to file it as a joint filing and place it and place the proceeds in an attorney's trust account, essentially unless they had a signed agreement otherwise.
And do we know when that order was entered?
Yes, November 16th, 2021.
All right, so I guess I'm going to get to down to the brass tacks here. So it sounds as though there may have been a text agreement between the parties, but there wasn't a written agreement per court order. Is that kind of fair to say?
My client would disagree. He said we went back and forth, and he ended on like, hey, we don't have an agreement, and he attached that text to the reply saying like, no, it's not agreed. put it in the trust account. And so for him, that's where he left it. So they negotiated, but never resolved it.
But the only bank account that was provided to the financial or the financial folks that prepared the tax return was the Miss Gibson's routing number.
Correct. And then we still don't have, I believe, those banking records, and that's part of the compel. So we really don't know where it went, other than no other opposing counsels indicated that they have.
Okay. Ms. Gibson, if you want to reply to anything that I just asked about, please do so.
Yes, Your Honor. As I said previously, petitioner and I did agree via text. Any conversation that we had after that, they were mostly verbal. He kept asking me where his half of the refund was. And my responses to him were always, I need to hear from your attorney to know that I can give it to you. My fear was that I would give the return directly to him or through his counsel, and that I would get in trouble with the court later for getting him his half and create an issue down the road. I made multiple attempts to resolve it and didn't get any clear indication from counsel other than that text from petitioner that he was aware that his attorney was going to draft an agreement of some kind. I sent those responses to her, and then I never received it. As I said, and then counsel and I spoke on March 6th of this year. She said to get her a half. I went and I dropped it off the next day at her office. I've been trying to resolve this. So I would just ask the court to not find me in contempt or order any judgment or fees related to it, because I've been trying to get it resolved. And I even gave petitioner in the text that I included, I believe it was Exhibit B, or I'm sorry, Exhibit C, the contact information for our tax preparer so that he could submit his information. And he never provided it to me. He never, to my knowledge, provided it to the tax accounting firm. So they just submitted the return and put it where it had gone the other 8 or 9 years that we filed our taxes together. I didn't know his routing information. Otherwise, I would have provided that to them so he could directly get his half. I don't know what else I'm supposed to do other than I diligently tried to get it over to Miss Baldwin. And until I got confirmation from her on March 6th that I could do so, felt that I couldn't, as I didn't have representation and I didn't want to get in trouble with the courts.
Does the court want any rebuttal or no?
Well, I guess, and please correct me if I'm wrong, but it appears as though both parties had access and had to sign off on the tax documents as they were filed. Is that correct?
So DocuSign doesn't automatically send you an email with a copy. It has you verify who you are, but it's not automatically providing you a copy. So my client essentially click, and all of a sudden it's done and it's closed. And so for him, he believed he had done what he was supposed to do in signing the taxes provided for him. The issue here is not the tax return. The issue here is that they did not have an agreement to split it from the initial filing. That the court order, which is, it's in the order of child support, specifically says that it's supposed to be held in a trust, an attorney's trust account pending further court action or written agreement of the parties. So we don't have either of those. And so the issue is where Ms. Gibson kept the money from essentially July, August until my client received half as a way of, I would argue, compromising to resolve at least that piece of it. So the issue is that she withheld it, kept it secreted. We didn't even know how much it was. And again, we had asked for the tax return and discovery. So these are the issues on the contempt. So again, we've addressed how much, but if she believes it was agreed, then there's no reason for her to have withheld it for the entire time. My office has always been in the same place. She could have provided a check at any time.
Your Honor, if I may respond.
No, I'm okay now. Thank you.
Okay.
All right. Let's hear the last issue. So the motion for relief.
So motion for relief, several different issues. So the first is child support overpayment. Children were placed with my client back in November. There's a lag between that placement and entry of the order of child support. Division of Child Support continues doing their thing with the last order on file, meaning they continue to garnish my client. Ms. Gibson, knowing the children had been moved to my client, continued to receive those funds and kept them. There was a overpayment of over $1,000. At this point, we were able to confirm that she's paid back $500. That leaves a balance of $538.72. She doesn't dispute that. That should accrue interest at 12% because essentially they are funds that she knew she was not supposed to be receiving, and she received them and kept them. She could have just turned them right around to my client and didn't. Money going out of the children's household. While she, we're asking that be paid back at $200 per month until paid. Pretty straightforward. The next issue is my client lives up in the Seattle metro area. He's asking to be able to sell his gas guzzling truck so he can buy something rational and affordable. He's asking essentially if he gets an offer for $12,000 or more that he be allowed to sell it. We're asking the court to set the floor, not the ceiling here. That really, I think Ms. Gibson in this sense just doesn't understand what we're doing. She doesn't seem to disagree about the sale. She just wants it to be sold for more. My client wants it to be sold for more too. But if he can sell it for $12,000, he should, because there's a lot of transportation of these children up and down the I-5 corridor. It's very expensive driving a huge truck. He does sometimes use his parents' vehicle. Again, his goal is to get a vehicle so that he doesn't have to use his parents' vehicle or his vehicle, neither of which are fuel efficient. So pretty straightforward on that issue. Whatever he sells it for, that's what he's going to be awarded to him as the line item in the balance sheet, along with the debt associated. The next issue is these parties have a real property home. We're asking that the house be placed on the market for the summer selling season and that be placed on the market essentially as of mid to late May. The home has has a value of approximately $300,000 to $400,000, depending on how you value it. There's over $100,000 of equity in the home. In this case, Mrs. cannot afford to live there. It's just not financially possible. When you look at her income and her obligations, even if you just look at some of her obligations, she just cannot make that mortgage payment in any rational fashion. She presents no evidence that she can refinance the home into her name. And again, she's not refinancing the current debt. She has to refinance to pay my client his half of the equity. She just can't do it. She's had at this point essentially 2 years to be able to show that she could refinance the home. She's not showing that. She's not showing it here. She's not even attempting to do it here. I would certainly object to any kind of settlement negotiations. Those certainly are not appropriate to be considered. Those are her offers, not ours. So again, we shouldn't address those or consider those at all. We did the math for you, not once, but twice. There just is no way around. She cannot afford this home. It's not possible. Just simply looking at child support obligations and child care obligations as her percentage share, she just doesn't have enough to live and make that mortgage payment. This is one of the major assets of the home. We want to maximize that asset for both parties, and we want to minimize risk. We do have risk here. Mrs. is paying late. She doesn't deny that. She says, well, I'm not having to pay a late fee, but you see her starting to pay later and later, approaching that late fee. Again, these are indications that she cannot pay. This is rational and reasonable to place the home on the market. We can have an agreed realtor. If we can't, we can each present 3 and the court can pick a realtor. That's fine. But again, appropriate, it's reasonable. Kids aren't living there. This is not their home. Kids live with my client up in the Seattle metro area. We need to move on. And again, minimize the risk and maximize the asset to both. Proceeds would be placed in an interest-bearing account or an attorney trust account. Either is just fine. Next issue is 2022 taxes. I believe we're agreed that the parties should file these separate. They separated in 2021. There's no reason why they shouldn't file married filing separate for 2022. We're asking that my client be able to claim the family home. He did pay spousal maintenance for 2021 and 2022. He continues to pay maintenance, and that Mrs. has a credit off of her child support payments. She's receiving a credit that is essentially, instead of just trading money around, she's getting a credit off of that and spousal support. So it's appropriate that he be able to claim a significant portion of that. Mrs. sort of presents, I would argue, a red herring issue of, hey, he should have been paying these taxes all along. A, she only raises this now, and B, when you look at the underlying temporary order, it says Mrs. is responsible to pay the mortgage, which includes the taxes and insurance. It's a single payment. They aren't differentiated, and we're asking the court for that clarification too. And again, one more reason to sell the home. As far as primary care providers, I'm hoping that we have an agreement and that Mrs. agrees to language there. Children, again, were moved up to the Seattle metro area. We want to have providers where they are. The respondent wants to maintain their local providers. Fine. They can do so. My client's not being unreasonable there. Just their appointments get set up in the Seattle metro area for all sort of standard appointments. So my client isn't then spending $100 in gas to drive them to a dental cleaning and losing a day of work to do that. We are asking finally that all communication be via our family wizard. There's a lot of sort of he said, she said in some of these communications. And my client says, I just want to communicate via our family wizard so mom can't kind of pull this, well, I didn't remember that, or I didn't hear that, or you didn't say that. He's like, I provided her with all the notice in the world. Let's do everything for our through our family wizard so that way no one can make those statements in the future. Finally, we are asking for fees. A number of these issues are pretty straightforward. We're just in a position where Ms. Gibson wants to maintain a home that there's just no way she can afford. And so similarly, should have had to bring the primary care provider issue for the court, but that's where we are. Some amount of fees is reasonable because we're having to come to court to address these issues where I think reasonable parties would have come to an agreement.
What did you indicate that he's paying that he should be able to claim the home on the taxes?
Spousal support. So the court ordered spousal support that I would argue was really to prop up the house. And so he's been paying that through from 2021 and now it's really worked into the order of child support. So I think she receives a $250 credit or about that off of child support. And you can see, if you were to look at that, or you can see it like written in. And I had the court do that just so that they weren't, he's paying her and she's paying him back kind of a thing. Just do it all at once so there's one transfer and not two.
Okay, thank you.
So in regard to the overpayment for support, I was unaware that there was any delay when the court entered into there was any delay in overpayment. I did that $500 payment. I was under the impression that took care of an overpayment. I was never told that anything in addition was due up until this motion was filed. So if the court finds that something is still outstanding, to be repaid at an amount of $100 a month instead of $200. In regards to the vehicle sale, I'm aware that petitioner has wanted to sell his truck. Previously, when I had counsel last month, Mr. Flay indicated to me that Ms. Baldwin had created a proposition for him to value the truck at $15,000.
These are all settlement negotiations. They're not properly before the court.
So that's correct. So I guess what is your opinion based on any conversations that you had with your attorney about the sale of the truck?
Okay. My conversation with the attorney was that the $15,000 proposed offer was a good value for the truck. And he did indicate to me that Ms. Baldwin had said that language would be drafted that if the vehicle sells for more, that it would be valued at the higher rate, but that the $15,000 was a good offer and that we should accept that. And I told him that if that's what he believes, then that's what I'll go with. And that I would receive a document to sign that we agreed to that. And then I never received anything. I didn't have counsel. And then Ms. Baldwin reached out to me and said that now it's being offered at 12. I understand that petitioner drives the vehicle to and from work. He's never driven the children down here in this truck. The children's car seats just simply don't fit. So he's been using his parents' vehicle. So to try and relate any of the wear and tear to driving between the two homes, I don't believe is accurate. So I feel like we should agree to that proposed $15,000 value or higher, whichever is greater. But I will defer to the court in that matter on whatever the court feels is best. In regards to the home, I've never paid the mortgage late. I've never indicated to Ms. Baldwin that it's been paid late. It's never accrued any late fees. I attached as Exhibit F my mortgage statements and bank records to show that it's been continually paid on time. And that petitioner claimed it's negatively impacting his credit, though he provides no proof of that. On the contrary, I provided proof that the credit monitoring app that I use show no payments have been made. And so it's not been negatively impacting my credit. In addition to that, to ensure that I don't fall behind on it, I've been paying petitioners obligation to the homeowner's insurance and property taxes that's wrapped in as our escrow part of our mortgage payment. The temporary order entered into the court on November 16th of 2021 states that the parties shall split 50-50 all other bills of the community, including but not limited to the HELOC, which is our second mortgage, property taxes, and homeowners insurance. I've made all of those payments to ensure that the house is paid on time. In addition to that, so that was signed, as I said, signed and entered, I believe, November 16th of 2021. And then additionally, this was brought back before the court in a hearing on March 29th of 2022, and amongst a number of things. So it should be, I believe, reflected in the court minutes that the court ruled they wouldn't make any changes regarding to the expense of the family home, which meant the property taxes and the homeowner's insurance that should be split 50-50. I've been paying 100% of those payments to ensure that the home is paid timely, to ensure that I don't fall behind on any of my bills. So as such, he's continued to not pay that obligation for the past 16 months. So I believe that he owes me for that bill $2,692. I have suggested to Ms. Baldwin that we use that as an offset for current childcare costs. I don't know if that's something that the court can order, but I believe it could be easily resolved outside of the hearing. But I just want to point that out, that I've gone so far as to pay his court-ordered obligation in order to maintain this home. And so I ask that the court not order the sale of the home at this time. I feel like petitioner is trying to create a problem that hasn't yet existed. It's never been late. All bills are paid on time. I have unofficially spoken to our mortgage broker who believes I would qualify for a refinance.
Okay. It's not in the court record. It's not even in her declaration. It's hearsay.
Yeah, I don't, we can move on from that, Ms. Gibson.
Okay. So I would just ask that the court give me 6 months to attempt a refinance so that I can see where my options are. I believe I can afford the home. Yes, petitioner does have the children, but that is temporary per the most recent court orders from November. It was indicated that it was a temporary change. And I understand that that's not before the court right now, but it's not permanent. So I don't want to lose the home that my children have grown up in and known all of their life. If the court does order that the home be sold, I ask that the proceeds be split 50-50 and not placed in a trust account. I would need access to those proceeds in order to make other living arrangements. The 2022 taxes, I do agree that we should be allowed to file them separately, and that I be allowed to claim one of the children on the taxes, because that is I believe is what's fair for each of us to claim one child. If we alternate children, I'll leave that up to the court. The petitioner didn't make a single contributing payment towards the house in 2022. So that not the property taxes, that taxes on those payments, I don't believe petitioner should be allowed to claim on his 2022 tax return because he didn't make those payments. I made the entirety of all those payments, Your Honor. So I don't believe it's reasonable that he be allowed to claim them. As regarding the medical providers, I do believe Ms. Baldwin and I have come to a tentative agreement that the children, will be seen by the provider that's in the area where the residing parent is. So I don't have any issue with that. I just ask that the court not award fees in this matter. A lot of these concerns could have been resolved outside of a court hearing. I attempted to try and resolve a number of them with little to no response from counsel. And as it's been indicated in the responsive declarations, we've come to an agreement on the providers since that motion was filed. That was something easy that could have been taken care of.
Child support's very clear. She doesn't deny. I'd ask the court to adopt my figure. $200 a month is reasonable and it should accrue interest. This sort of, I didn't know. You received money in your bank account. You saw it come in. You did know. You chose to keep it instead of giving it back to the primary parent. The vehicle sale, again,
sorry to interrupt, but double check. That is what she already paid $500 to your office for.
Yes, and
so there's about how much left? $600 or $700 left.
Yeah, 560 something. It's in the motion. Hold on, I can tell you exactly.
Sorry, I threw you off there.
That's okay. $538.72.
Thank you.
So that's what's owing. You should accrue interest since December at 12%, because that's the child support percentage. And again, we're asking for $200 a month because she kept it when she knew she shouldn't have. She's asking for $100 a month, whatever. I'll trust your honor's discretion. The vehicle sale, she essentially wants to trap him in a vehicle that she admits doesn't fit the kids. That's ridiculous. Unless he sells it for the highest possible blue book value. That's not appropriate. Whatever he sells the vehicle for is going to be what they get for it. The children should be able to ride in a safe vehicle. You should have the ability to have a fuel efficient vehicle. We're asking that if it sells for $12K, that's what it is. If it sells for 15, that's what it is. So she's not getting shorted even $1. It's just whatever it sells for, we're setting the floor, not the ceiling. As far as the home, we do see that she's paying late. Mortgage based on her own documents is due on the 1st. We have her paying on the 6th and then the 13th. We see it progressing later and later, especially in 2023. So what we don't want to get into is where we're getting really, really late and really delayed and having significant impacts. Again, this will give me 6 months, but that completely eliminates the primary selling season for homes. We want to put the home on the market when it maximizes the price for both parties. We can come back once it sells and address what to do with the proceeds at that time. I'm not really hung up on that issue. My client just wants to maximize how much both parties receive from the sale of that home. There's just no way she can afford it with her income. It's not possible. And once you're in a position where it's not possible, it's inevitable, we should be maximizing the value for both parties. As far as the 2022 taxes seem to be agreed that those should be filed separately. Again, my client paid substantial maintenance in 2022, initially $1,700 a month, then it was reduced to $1,000 a month. Then there were further reductions later in 2022. So again, we have really substantial payments that have been made from my client, and really those were to prop up the mortgage. And so that's why it's appropriate. If the court wants, you can sort of split this and say father's going to claim both children and mother claims the home. That might be a way of sort of equalizing those tax benefits between the two parties. I do think these are appropriate, sort of holding my client in a vehicle that he really can't transport the children in doesn't make a whole lot of sense. So things like that are reasons why we're here. So we're asking for an award of attorney fees and relief.
As for the overpayment of child support, the balance is $538.72. I will order that the 12% interest take place, and I'm going to order a minimum payment, $125 a month until that's paid off. The vehicle sale, I think I understand the blue book value. I don't know. Frankly, there wasn't a lot of discussion about the condition of the vehicle. I think it's appropriate given what we're looks like a 2013 Toyota Tacoma. Access cab makes me think jump seats in the back, so that's why so I think a private party sale, yes, the blue book says the $15,000 to $18,000 range. I think I would imagine that Mr. Gibson wants as much money out of it as possible as well. I think if he can sell it for anything above $12,000, that'll be authorized by the court. And then obviously that'll be reserved for division. The home. So I did review the mortgage payments. So there was a kind of a summary on the, I guess, Exhibit F. And then I reviewed some of the statements that were also included in Exhibit F. I really see September 16th is the late one for 2022. All other payments are made within, well, I guess February 13th, 2023 was a little late. And then March 7th, 2023. But there's 3 that are arguably, and I don't know what the grace period is on the home. I'm not going to order that the home be sold at this point in time, but I would, but I'm going to put a kind of a deadline for Ms. Gibson. I'd like to review this in 2 months. So instead of 6 months, I'm going to give you 2 months to look at what you can do for refinancing. And if you can come up with a plan here, but I'm not going to order that at this point in time. Ms. Baldwin must have read my mind. I wrote 2022 file separately. Dad gets the kids, mom gets the home. And then we'll reserve for 2023. And then request for attorney's fees of $1,500. I think Ms. Gibson doesn't know this. Ms. Baldwin knows this. As do most of the attorneys here. I'm usually very reticent to order attorney's fees in cases just across the board. I reserved on the motion to compel any fees. And at this point, I'm gonna reserve on this pending our review in May. I'm gonna return to the contempt, and this is a difficult one for me. I think clearly Mr. sees it as relatively black and white. Mrs. doesn't. There appeared to be an agreement according to Mrs. There didn't according to Mr. There was some access by Mr. to that tax return. Arguably, he could have made the change on the tax return to include his attorney's trust account. So it went where it needed to go. I don't really have the information provided by Ms. Gibson. It obviously was an attempt to be thorough and provide as much information as possible, and I appreciate that. But the tracking of the DocuSign information doesn't really give me a lot of insight as to who looked at it last, what was seen when it was accessed. I guess the opposing argument could be Mr. probably shouldn't have signed off on it until he reviewed it all. So based on kind of just the muddiness surrounding that, there's a lot of muddiness surrounding that, but the language in the prior order is relatively clear. And Ms. Gibson seems like a very intelligent individual. She was very effective in her responses and filing those responses, but she sort of just sat on this money. And I understand she was concerned about getting in trouble with the court. I think probably what she did was the worst option for that. But I understand the confusion. I'm going to make a finding of contempt in this case, and I'm going to order the $100 sanctions. I'm not going to impose any attorney's fees on that. The attorney's fees for the motion to compel and motion for relief will be reserved for our next review hearing. All right, we'll set presentation for April 11th. If that's agreed upon before then, we can strike that portion from that date, but we'll set presentation at this point to 4/11/23 at 1 for adequate cause and request. Well, there was an objection to a move.
That's correct, Your Honor. And I think from a practical standpoint, I'm not going to get too far into the adequate cause. It sounds like that's stipulated. This comes before you on Ms. Vick's request to relocate. I'll get to that here momentarily, but I think given the fact that this is involving a change in school district, another proposed change in residence, that adequate cause is granted under the statute. I think that's the easy issue. So I'm not going to go too far and delve into that. I will focus my comments on some of the practical issues and the practical concerns that my client has for his 12-year-old child, Aubrey. And this is a case, I think, where he does a pretty fair job detailing those concerns and kind of the history of this in his declaration. So I'm going to reserve a lot of my comments. If the court has questions, I'm happy to answer those. But I'm going to stick pretty much down to the kind of the facts and boil it down to what I would perceive to be rather simply. Again, this is a case in which Ms. Vick has been the primary parent of Aubrey. And it's been that way since these parties were in court on a parenting plan action years ago. And this is a case where my client details for you his attempts, and I think it's largely undisputed that he's tried to be accommodating of mother and her various arrangements. He's been extremely patient. We were extremely surprised when we saw the accusation that he had been retaliatory in some manner, shape, or form, because I think the reality is this is a case where he probably should have been a little more proactive some time ago in addressing a lot of these concerns. From a starting off standpoint, this is a case in which mom now this is her fourth proposed relocation over the past year alone. Yeah, this is a child who is 12 years old. This is a case in which we just addressed this back in the fall. Now, my client details for you, and again, I think the record is complete, that shows a modified parenting plan was entered back in September.
due to mom's then requested change in residence back then. And again, this is literally just history repeating itself over and over again. Mom meets a new individual, moves in quickly with new individual, exposes the child to the new individual, and then they break up. Starts the cycle all over again. Again, this is the 4th time in the past year. Child initially was being homeschooled. That was not going well whatsoever. Child then transferred schools. And again, I want to make sure that we have the chronology correct. She was homeschooled last year, then transferred to the Napavine School District, then the Nisquality School District, now apparently Chehalis. And we have information now that mom is in a new relationship that was somebody who, again, lives outside of the local area. My client, again, tells you and is quite candid in his approach to this. He has tried, probably to his detriment, to co-parent, to communicate, to foster a lot of these frequent moves by mom over his objection. He acquiesced eventually. There's a new parenting plan. Mom promises to not do it again. And then here we are. The ink is barely dry on the order that we just entered in the fall, and we have a new request. Contained in that new request are concerns. Mom states what? Mom implies in her request that, well, I want to be able and granted, I want the court to do that on an emergency basis because there's some kind of turmoil in the home. She now says, well, that wasn't really what I meant by that. It was a poor choice of words, but nonetheless, it prompted her to come to court, ask for ex parte relief, that the court grant that petition and allow her to move on an emergent basis because of issues that were, again, happening in her then boyfriend's home. She's now out and she takes the child with her, enrolls the child in a new school district, and child is essentially asked to start from scratch again for the 4th time in a year. This is not conducive or effective for this child's well-being and growth. This is certainly not conducive for a child who, at the age of 12, that's usually a social age, coming into their own, learning some independence. This child has no opportunity to make lasting friendships, to build any kind of stability inside of a school, to get to know her surroundings or her environment beyond a very brief period in time. And that's concerning. And I think if you look at the information my client has provided you by way of grades and academic performance, we see a child who is subject to frequent school changes and frequent environmental changes in her life. Currently, Aubrey is getting 3 Ds and 3 Fs. We provided you information that shows she's been tardy upwards of 30 times. Most of those are to first period. We've given you information, and my client cites his concerns in which he states the child is being told by mom, well, essentially make an excuse that your dad will buy, tell him you're having female issues or menstrual issues, and that's why you're going to miss school. She's collaborating with the child to get her so that she doesn't have to attend school, putting herself in a friendship type role as opposed to a parental type role. Also have the issues with modeling. And again, this is a 12-year-old child who's watching mom, who's readily aware of what mom is patterning for her as far as behaviors go and what it takes to be, again, a responsible young lady. And mom meets a new guy, moves in with a new guy. And mom's been very unable to keep any kind of consistent job or employment. Rather, the whole world revolves around who it is she's dating at any given time. That's concerning. My client details for you, and again, I think it's largely undisputed. There was some red herrings that we would certainly submit in mom's responsive pleadings that we don't agree with, but those are all going to be vented out by a guardian ad litem, assuming that one is appointed today, which we think is appropriate. But we have these excuses from mom where she says, well, dad's trying to buy the child, dad's providing for the child, they go on vacations, dad is stalking the child. And again, it's interesting to look at this. This is a 12-year-old kid. And my client details for you that he lives in a very spacious, very safe, very comfortable home in Kelso. He's been in the same industry and field of employment for 25 years. He has a long-term wife. He was successful in raising his older children, and he has no intentions or desire to move anytime soon. His life is here. He's built it. He's done a remarkable job of that, and he offers the stability and structure that this child so desperately needs. Aubrey is a smart little girl. Aubrey is a girl who is emotionally intelligent. Aubrey is a little girl who just simply needs some kind of structure and routine that her mother has proven she's just incapable of providing. There's concerns when mom says she's going to start some kind of a tattoo business or something in the automobile industry or something. She's got 3 different references for areas of employment. My client tells you that he's very skeptical of that, and he has every right to be considering the issue of this case and how we progress to this point. My client is somewhat concerned when mom, and I think this is always interesting when you review these responsive pleadings from the other party, and they come back and the verbiage is pretty important. Mom refers to the child as my child. Aubrey is her possession. Aubrey belongs to her. My client states for you his concern that mom is telling the child, well, dads are kind of optional. You don't really need a dad. You're with mom. Things will be all right. And then threatens the child with these types of fear tactics of you're going to have to talk to the judge. And if that's what you need to tell the judge, you don't want to live with dad. Then on the other end, alleges that my client is somehow involving the child in this litigation. My client details for you he's never had a discussion with the child about this. As far as he's concerned, the child doesn't know about any of this outside of what she brings back to his home from communications with mom and communications that unfortunately he was privy to related to, well, you just need to come up with an excuse and tell your dad why you're missing school. After all, you're my child and your dad is just optional. And again, dismissing one parent in that regard while making the decisions that she's making is certainly not in the best interest of this child. It certainly leaves for cause for concern moving forward. And again, the fact that mom could place this child in 4 different academic settings in 4 different homes over the course of the past year is extremely concerning. This child is not doing well in school, and she is not living up to her expectations or her capabilities. And at this point, there's only one real option to change that and fix that. And that's probably what should have been done a couple of years ago. That's uprooting the child, putting her in my client's primary custody, ordering that she attend schools at the Kelso School District. My client's schedule is very conducive for ensuring that Aubrey is appropriately taken care of. He's shown again that he's suited as a primary custodian, and he has an extended family and a current wife who's very closely bonded with Aubrey. The two have a very good relationship, and he's not going to expose her to person after person after person, which unfortunately mother has done and been very quick to do over the course of the past several years. That's what we're asking for. We also think a guardian ad litem being appointed is appropriate. This is a case again where we were just here in September based on another relocation. My client acquiesced to a final parenting plan being entered at that time, which gives him significant time with the child. He paid for my services in that. He's the one that kind of pushed that boulder up the hill again to accommodate Miss Vick, accommodate this relocation under the guise that it was the last time. And then less than 4 months later, here we are again on yet another relocation matter. This time tends to be a little bit more serious as it pertains to her request, in which she tells the court that she's living in some form of chaos while at the then boyfriend's home. And again, I don't know if that's one boyfriend ago or 2 boyfriends ago, but every step of the way, she's introducing this child to a new romantic partner. And we think that, again, is extremely brazen and probably very inappropriate to do with a 12-year-old child. We are asking the court to find the adequate cause. I think that's appropriate under the statute. Also asking the court to appoint the guardian ad litem as we have proposed and award custody to my client. This child's going to need to change schools again. Given Miss Vick's track record, if the child remains in her care and custody, that's probably going to be short-lived. Because by premise, every 3 months or 4 months, this child is asked to relocate and essentially wipe the slate clean and start over again. Kelso is more stable for her living, but dad is much more stable, and dad can provide a better environment. And we think it's certainly a high time that the court adopted our proposed relief. And again, probably something that should have been done a couple of years ago. Finally, in regards to child support, my client is paying child support. He always has. He's been regular, consistent in that as well. We are asking if the court does grant the change in custody to just temporarily suspend that and relieve him of that obligation effective when the custody change might occur. And then we can readdress that when the time comes. And once we exchange income information, we can actually run some figures on that. I didn't see that Ms. Vick had provided any financial information. My client didn't either. But again, that was by design because it's not about the finances right now. It's about the care and support of this child who is quite literally struggling mightily.
All right. Thank you, Mr. Zandy. Ms. Holder?
To go over and kind of rebut in that. First of all, I would agree with counsel that there has just been some miscommunication in this matter. And we would agree that a guardian ad litem would be a good idea to kind of, clear and put some light on the situation so that both sides, the truth will come to light. As far as my client being the primary parent, that is true. Aubrey has lived with her mom since she was born. I believe we detailed that in her declaration that was submitted to the court. This is not the 4th move. This is not the 4th school. I'd like to go over a school timeline to give you an idea of the actual timeline for schools, as well as reasons why Aubrey is not doing as well in school as everyone would like her to. First of all, she was in the Toledo School District, and then COVID hit in March 2020. She was there until June 2021. She was there until June 2020. That was COVID. That was online learning. She was enrolled in the Toledo School District. She did online learning through that. Then when school got back in August of 2020, it was optional, hybrid learning, whether children want to be vaccinated, wear masks. My client had a health concern. She did not believe that it would be a good idea to subject her kids to being in school and with masks, mask on, mask off, just a big health concern. So she had then again enrolled her children in homeschool, and that was through Connections Academy, and that was through the state of Washington. She's kept the children enrolled, including Aubrey, from August of 2020 until February of 2022. She didn't have to move for this. She was in Castle Rock during this school, so she did not move during that time. Then in February 17th, 2022, she enrolled Aubrey in Napavine when she did move out of her home. And the reason that she moved out of that home was due to financial reasons. She was not going to be able to work because the work she was at the time was cutting its hours. She wasn't going to be able to afford rent. It's going to be an additional $500. She was already dating this man, and he offered to let her and her daughters come and live in the home so that she could spend more time. She is already a work from home parent, and I'll get into that for her work history in a moment. But it was more an issue of rent is going to go up. She can't afford it. She's already working. She just got her job cut. So what was convenient and best for the children, there was nothing, there was no accusations of domestic violence. There were no issues going on to move those children into that home. She then lived there and then enrolled the children in Appledine. Enrolled Aubrey in Appledine. Then from August of 2022, so the next school year, she was enrolled in the Squally, and that is the last time this case was heard, and that was in September for moving her to Squally Middle School. Now, this is the 5th school since March of 2020, which includes the COVID pandemic. So now she wants to enroll her in Centralia, which is closer to both parties in this case. And one of the main reasons that she wants to relocate her daughter to this school is actually twofold. First of all, it is much closer to both the parties. She is spending a lot of time and money on gas. It is not cost effective for her to keep her child enrolled in the Squally. Second of all, the school, from my understanding, is a little rough. There are kids fighting. There's all kinds of issues. One of the children in her and Aubrey's class was suicidal. So her mom wants to get her out of there for her mental health and because it's not the best environment. Going toward her grades, already since Mr. Duprez brought this proceeding, she's already brought one of her grades up from a D to a C-. She's working on it. As far as if there were any missing assignments, she's been filling those in. She had good grades last semester, A, B minus, A, B minus, B. Those grades are not great right now, and that is because this proceeding was started on February 7th. The new school term started on the 6th. So the entire time she has been in school for this semester, these proceedings have been going on. Also, as to the allegation that Mr. Duprez has had nothing to do with telling his child about these proceedings, his wife is. She has conversations, and she had one this past weekend with Aubrey while they were at the beach.
Your Honor, I'm trying to be patient, but we're getting way outside the scope of the declaration. This is all new information that we never had the opportunity to respond to. I just object to anything that's not in the pleadings.
That'll be noted. Go ahead, Ms. Holder.
I would like to respond to say that if it is going to be brought up in the argument, I would like to rebut it. Aubrey is having discussions with her dad and her stepmom about what's going on. She knows. I don't want to say specifics because, again, as counsel pointed out, he probably does not know about this information. But yes, there are conversations going on, including bringing up financials and how her mom can't afford this.
And just same objection.
As far as the tardies go, there are 30 tardies to date. Some of them include Mr. Duprez weeks. On Monday, he drops his child off. So he is also not taking his child to school. Also, 4 of those are excused tardies. 10 of them are from periods including, they're not from first period, they're from 3rd, 4th, and 6th period. There's 2 from 3rd period, 1 from 4th period, 3 from 5th period, and 4 from 6th period. So a lot of the tardies that she is getting is because she's a social butterfly and she doesn't get to class on time. And her teachers have brought that up with my client. Ms. Vick is planning to meet with her teachers, and she has. She's met with them, and she has another meeting lined up on the 29th with all the teachers. So she is addressing these grades. Aubrey is very stressed from the situation that's going on. I think to say that there are 30 tardies and the majority of them are from first period would be accurate. There are a lot, but Ms. Vick has gotten her child to school on time, and the teachers note she's not getting to class on time because she's talking in the hallway with her friends. And I would assume it's because she's stressed out for this situation.
And again, Your Honor, object to the hearsay and the fact that this wasn't contained in any pleadings.
Yeah, I won't consider anything that they should not. So that I'll note that. Go ahead.
Well, in that case, Your Honor, I would just like to note that in looking at the tardies, they are mostly from periods while she is already in school, but after she's already been dropped off, because she's just not getting to class on time. And we did bring up in our declaration that she is a social butterfly, and that's why.
Just before you move on from the school thing, can I ask a clarifying question? You said that the new semester at Chehalis or Centralia?
I believe it's in Squally. That's where she is.
She's in Nisqually currently.
Yeah.
Okay. So the new semester, quarter, trimester, whatever it is, started February 6th.
Yes, I believe that was in Mr. Duprez's declaration in his reply. I believe he filed that with the court.
And I just want to make sure that I heard what you said correctly. You said that you think Aubrey is stressed out because since basically this was started the day after that.
Yeah.
So she's stressed about the situation.
The
So
new-
she knows about this in some way.
Yes, Your Honor. The new school term did start on February 4th, which is Saturday. And so I believe if you look on the last page of the reply, you will see that there's the attendance records, and you can see term 3 starts on 204.
Okay, thank you.
You're welcome, Your Honor. And so, yes, it did start. And then the first day would have been that Monday, which would have been the 6th. And then this proceeding started on the 7th.
Okay.
As far as Ms. Vick's work history, she's been in the insurance industry since she was 18. She currently works for Farmers Insurance, but it's commission-based only. So she is only contacted for work whenever someone wants a quote. So that's one job. She's been doing that since August of 2022, or since August of 2020. But she has worked in the insurance industry since she was 18. There's even newspaper write-ups about her. As far as the auto repair, she was working under the table for 3 months. And that's one of the reasons she moved. That is the reason that she moved to Centralia, is specifically because she was going to work at an auto repair shop she was already employed at. But then because she couldn't get secure housing fast enough, they just decided to not hire her and stick with the person that they were going to have Ms. Vick replace. She does not work there now, but that is a reason she moved. She currently, her main job is public partnerships. She's been with them since the pandemic, I believe. The company's based in Maine. Her job is based in Virginia. So she does work East Coast hours. She does work from home. So she is available to be with Aubrey during the day and also her other children. She works as a fiscal management specialist, and she rolls Medicaid patients in home care. The tattoo business that she would like to start is permanent makeup. Your Honor, I'm not sure if you're familiar with permanent makeup. So she has already been to school for that. She decided to pursue it in October 2022. She enrolled in the class and took the class necessary to become licensed in January 2023. She is only licensed to do brows, but would like to, she would like to expand that to be able to do eyebrows, or do eyeliner, maybe do lash extensions as well. She wants to do areola construction specifically for cancer patients who've had mastectomies. She also would like to get into micro scalp pigmentation. So that basically is tattooing follicles on someone's head to make it look like they have not had hair loss. She would like to do that. That is additional money. She has not been able to pursue this because she had to put it on hold because right now she had to hire legal counsel and she's not able to afford the $300 a month to rent the space. So she had that already and lined up, and then this proceeding began. So she already has the training. She already has the necessary skill set. Her goal is to have a full salon to be able to do all these things. And because Aubrey is interested in lashes and makeup and hair, she would like to someday have a permanent salon established so her daughter could join the family business. So she does intend to stay in the area. She rented a house, not an apartment. The allegations that were made in the declaration are untrue. The house, while Aubrey does live in the basement, it is heated. There is a closet. It's located under the stairs. There are cabinets throughout because it was previously used as a home office. There's nothing to say that Aubrey is living in squalor and she's been sent down to a full basement. As far as allegations of stalking, no allegations were made about stalking the daughter, about stalking Aubrey. That was never said. That was never said in the declaration. Those words were misconstrued. What we said was, and this goes to what my introduction was, there's a lack of communication here. Mr. Duprez and his wife have gotten Aubrey to have an Instagram account. Ms. Vick didn't want one. They went ahead and did it anyway. Ms. Vick believes it was because Aubrey said to her dad, oh, mom said it's okay. But instead of Mr. Duprez checking and verifying with mom, he just went ahead and did it. Okay, what's done is done. But then he won't share the passwords with the account. So Aubrey's mom doesn't know what's being posted. My client doesn't know what's being posted. She has no access to it. There is a tracking app on the phone, which Mr. Duprez brought up in his declaration. That's fine. We would ask that he share that information with my client. She doesn't know what's being tracked, what words are being excluded. That's perfectly fine and reasonable. But when Aubrey is with her mom and there's tracking software on her phone and she turns it off because she's with her mom because she doesn't want to know, like let her mom and her stepmom and her dad know where she is all the time because she's with her mom, they immediately will call or text her and say, turn the tracking back on. We know you turned it off. That seems a little unreasonable. Also, there are allegations, like the stalking allegations are because Mr. Duprez and his wife asked members of the community about Ms. Vick. It's not that they're stalking Aubrey. They are being responsible parents, I believe, but they're going a little too far and not communicating that with Ms. Vick. That can be solved with communication. I don't think that's unreasonable. But as far as asking members of the community what Ms. Vick is up to, she's not dating anybody. I don't know where they got this information. Ms. Vick doesn't know where they got this information. They think it's because they're reading Aubrey's texts and they're misconstruing information. She doesn't know. She's not dating anybody. She's only dated 2 people in the last 8 years. She's not jumping from guy to guy. I think to mischaracterize her in that way, quite frankly, is a little misogynistic. She's not doing that. She's not jumping from place to place at the whims of a partner. She moved into this apartment. She's paying for it herself. The last time she moved into an apartment by herself, the rent went up and she couldn't afford it. She happened to be dating somebody who offered. She did not go out seeking an arrangement to have a place to live because she couldn't do it on her own. She did it on her own. It didn't work out. Someone offered her something. She took it. And then as far as these allegations of, oh, there was some dispute at the home, it was nothing major. There was no police report filed. Nothing happened. There was no altercation. There's no allegation of that. Two people didn't work out. Things might have been a little tense. She moved out. There was no issue. Aubrey was there to see it. And I believe that the former partner did text her, sorry, I had to see that. And then from there, Mr. Duprez and his wife extrapolated that, oh my God, what happened? Something terrible happened for her to see. Like, no, it was just a little bit of a tense thing when Miss Duprez went to go pick up some pots and pans that she left or had been delivered. It was nothing major, and to blow it out of proportion, again, is a mischaracterization of what's going on. Again, I would welcome, and Ms. Vick would welcome a guardian ad litem in this case. I think there's just a lot of accusations that are going around that needs to be brought to light. I think Ms. Vick should remain, have full custody of her daughter. Right now, I believe it's a 40-60 parenting agree. It seems to be working out. Aubrey's happy. From what I understand from my client, yes, it's a stressful situation, but it would appear to me that the stress really started at the onset of this proceeding. There wasn't really an issue before this. As far as this being her fourth move or whatever Mr. Duprez is alleging, whenever the timeline, it's not the case. COVID interrupted her schooling. That's another reason. She's a 12-year-old girl. She just hit puberty. That's the reason that she didn't want to text her dad is she hit puberty. The time she didn't go to school, she had the flu. I don't want to get into the details in open court, but she was extremely embarrassed about an incident. She didn't want to tell her dad about it because apparently when she tells her dad or her stepmom about things, they laugh about it, think it's funny, and Ms. Duprez goes and tells her friends, and then they joke about it.
And again, Your Honor, we're getting way outside the scope of the declarations.
All right. Anything else?
I would just say that as far as the text messages, tell your dad something that's acceptable. It's because she didn't want to get into her healthcare issues with her dad because she was embarrassed about it. And if a child doesn't feel comfortable talking to their parents about a healthcare issue, I would say that, that's an issue between the child and their parents to why the child doesn't feel comfortable talking about those kind of issues. So again, we would ask that Ms. Vick be allowed to move would be allowed to enroll her daughter in Centralia. It is a closer school. It makes more sense. It's right across the street from an early start program that Ms. Vick plans to enroll her in later in high school, possibly. She is a very bright girl. She's getting a handle on her grades right now. Ms. Vick is working with her on that. She's meeting with teachers. She's doing all the necessary steps. This is just an unfortunate situation that Aubrey is in right now where she feels like she's caught between her parents. And I think that if we can get a guardian ad litem in and we can have better communication between the parents, I think this situation would start to repair itself. And we would also ask that Mr. Duprez pays attorney's fees on this matter.
All right. I think a GAL is appropriate at this point. There is, frankly, the stability concerns, I think, are prevalent in this case. And I think, understandably, some of the decisions made are a little bit questionable as well. So I think a GAL is appropriate. Point and height as the GAL in this case. I will make a finding of adequate cause. It appears that that's agreed, and given the circumstances we're in, it is similar to a handful of months ago. I'm concerned. There's concerns. I'm going to move because I got this job, but they don't give you the job because you don't have a house. I don't know. There's just a lot of things that have been stated that are concerning to the court. That being said, I don't see. And I guess my understanding, Ms. Holder, is that Ms. Vick is currently living by herself with her and her children. Just there's no significant other.
That's correct, Ron. There's no significant other.
Okay. So I'm not going to make a change at this point in time. However, I will express concern, and that may be something that needs to happen. I do want to see some input from the GAL. Ms. Height was here earlier, and I wish I could chat with her for a second, but what I'd like to see is even an oral interim report on maybe a 6 to 6 week basis, 8 weeks at the most. And then setting a final report in regular course.
Your Honor, if I
Just the
may-
fees on that.
Yeah, the fees on the GIL, he's gonna be responsible for that. Thank you, Mr. Manning.
We asked that be 50-50, just given the circumstances and the fact that we were just here 5 months ago and my client fit the bill for that. I think 50-50 is probably appropriate.
I would agree to that.
I agree as well. We'll split the GAL fees 50-50 private pay at this point. Anything that can be presented that's agreed ex parte, I'll sign and get filed as quickly as possible.
And I think I could probably be pretty quick on this order. It's just a GAL order and an order of adequate cause, and I'll just maintain everything. Can we set it for the docket next Tuesday, and I'll get that to you hopefully by the end of tomorrow, Ms. Holder,
That
for
works.
presentation date? Oh, you're not here next week.
I'm not here next week. I mean, I'm here, but I'm in trial. So if you want to do it the 31st at 8:45, and it can be struck if we have agreed orders.
That's inspiration to get an agreed order. So let's take that date, and then I think we'll probably come up with some kind of an agreed order. Our office gets along well with Ms. Holder's office generally.
Okay, so the 31st.
Yep.
All right, so that's right. Ms. Holder, that's my presentation docket is Friday morning at 8:45.